Hi, everybody. Today's Facts in 5 video is about the 3 types of probate in Connecticut. So you might be saying, wait, whoa, there's more than one type of probate out there? Yes. And the type of probate that you're going to need to do is really going to be dependent upon the type of assets that you owned at the time you passed. So throughout this talk here today, again, I'm going to try to keep it under 5 minutes just because this is one of our great Facts in 5 videos. We're going to talk about the 3 types of probate that are available for decedents who pass here in Connecticut. So the first type of probate is what's known as a tax purposes only estate, or a TPO estate. And what it means is that there are 0 assets passing through probate. So you might be saying, then why the heck do I need to file anything with the probate court? I have no assets that actually even need to go through probate. Well, the name kind of says it all, tax purposes only. Connecticut has an estate tax, and the estate tax works in a manner such as if you own a certain amount of assets, then you're going to owe a tax to the state of Connecticut when you die. Right now, that asset threshold you need to meet in 2022 is just over $9 million. As of January 1st, 2023, it's going up to be over $12 million. So most people don't pay an estate tax, but sometimes there's still going to be a need to file an estate tax return with the probate court under this tax purposes only estate process to simply prove that no tax is due. The most common situation where we see this is when there's real estate. So if anyone's seen any of my other videos, you know that jointly owned assets pass outside of probate. So that's one of those assets that doesn't need to go through probate to get out to the surviving co-owner. They're just going to get that automatically. But let's say husband and wife owned property together. When husband dies, wife will inherit the property, will own it 100%, but she's going to own it subject to an estate tax lien. Because the state of Connecticut says, wait a second, you might have owed a tax when you pass away. So until you prove to us that no tax is due, we're going to put a lien on your house. So that's what that estate tax lien is. So the wife is going to want to get that tax lien released because if she ever wants to sell the property or do anything with it down the road, that lien is going to need to be released before she's going to be able to do that. So what she's going to do is she's going to file that estate tax return along with the will, if there was one, and a few other documents that are going to be required by the probate court as part of this tax purposes only estate. She's going to get a release of that estate tax lien on the property, and then she's going to be all set. So that's what the tax purposes only estate is for. It's really typically a short timeline for completion. The exact timeline is going to depend on the specific probate court that you're in, but generally speaking, you file all the forms, you just wait for the court to process them, and then you're done. There's going to be a similar result or a similar timeline for the second type of probate, which is known as an affidavit in lieu of probate, or sometimes simply referred to as an affidavit in lieu. And this is when there are some assets that are passing through probate, but the total value of those assets are $40,000 is less, valued at $40,000 or less. And as a quick refresher, the only assets that are going to need to go through probate are ones that were individually owned by a decedent at the time that they passed. So if there's some individually owned assets, but the total value is $40,000 or less, you'll make use of this affidavit in lieu administration, which means that it's kind of similar to the TPO. You're going to fill out that estate tax return. You're going to fill out another form, which is the actual affidavit in lieu of probate, which lists the assets that do need to go through probate along with various other pieces of information. But then you submit all that documentation to the court processes it. The court is going to issue a decree formally transferring ownership of those individually owned assets out to the intended beneficiaries, and also, if needed, release of that estate tax lien, and then you're done. So just like with the TPO estate, really short timeline for completion. You submit all the documents to the probate court at once, and then once the court processes that information, you'll be all done. The third type of probate is the one that most people have heard about, and this is the full administration. So despite some of the horror stories that some people have heard, most probate estates that are a full administration only take about a year. It can take longer if there's some really big issues that need to be tackled, but typically it's about a year. And the full administration is required when there's individually owned assets, so probate assets, and the total value of those assets are valued at over $40,000. So in this type of estate, there's going to be a formal appointment of an executor, which means somebody's going to get a legal certificate from the probate court saying they have the legal authority to act on behalf of the estate, and they'll use that going through the remaining probate court process to gather all the needed information. So those are the 3 types of probates that are available in Connecticut. So be very aware of what you own, how you own it, because that's really going to dictate which one of these probate processes is going to apply to you. If you have any other questions, please contact us, and you can contact us through our website at kkc-law.com. My contact information is on there, or you can also go to our YouTube channel and watch some more of our really great videos, because we have some more information about probate, about how to structure your estate so you don't have to have assets go through probate. So please feel free to check out those videos as well.